Good morning, everyone. We're letting people into the Zoom room. It's about a minute before 9:30, so we're just going to let people get in here for a second before we start the program. Hi, everyone. We're going to start the program within about a minute now. It's just about 9:30, so we're letting people come into the room. Hi, everyone. It's just about 9:30, so I think we'll get going. Welcome and happy St. Patrick's Day. My name is Ken Ginder. I'm a member of Verril's Employee Benefits and Executive Compensation Group, and I'm joined today by my colleague Sam Baldwin, who's also a member of the Employee Benefits and Executive Compensation Group. Before we get into the substance of our talk today, a few housekeeping items. First of all, questions. If you have any questions, there is a chat room where you can post them throughout the program. In addition, at the end of the program, you can come off of mute and ask questions that way if you would like. We think there'll be time for that. So of course, during the program, if you could stay on mute, we would really appreciate that. A video of this program or a recording of this program will be available later on, probably by tomorrow, so you should know that. This program is one in a series of programs being sponsored by our Labor and Employment Group. The Labor and Employment Group has their annual update, which they are providing these types of programs on a monthly basis. They take place like this one at 9:30 on the third Thursday of every month. So next month, April 24th, there'll be another program. So be on the lookout for an announcement about that particular program. Also, under housekeeping, slides. The slides we're going to be going through will be available through a link in the chat function if you want that. And then continuing education type of credits. This program has been approved for one SHRM credit for our HR folks. And we have asked for and it's pending legal credit from the Maine Bar Association. So we expect to get one credit from them too. So you should, for the lawyers in the group, you should be able to get CLE credit as well. So with that, let's dive right into it. Sam and I are really excited to talk to you today about ERISA Fiduciary Governance with the subtitle, Who's in Charge? And the points to be made on this particular page, the first is a basic one. I think most people on this program will know what ERISA is, but for those who don't, it's critical that you understand that ERISA is an acronym for a federal law that governs employee benefit plans, okay? It's called the Employee Retirement Income Security Act of 1974. And the name is a little bit misleading because it governs employee benefit plans the employee benefit plans include retirement plans, like the title of the statute implies, but also what we call welfare benefit plans, which are things like your health insurance, your vision plan, your dental plan, life insurance, in some cases severance, a whole host of different benefits. So all benefits are governed by this federal law, and as a federal law, it generally preempts state law. So it's really important to have that sort of baseline understanding. The second thing point I want to make on this page is who's in charge. sort of a spoiler alert here. Who's in charge is going to be a fiduciary. Okay, that's the short answer. But what we're going to be doing today is examine why is it the fiduciary? Why is the fiduciary in charge? What is a fiduciary? Who is a fiduciary? What's the best fiduciary governance structure for your particular company? What should a fiduciary know, and what are next steps that you can take to make sure you're in compliance? So that's an outline of the things we will be covering over the next 55 minutes or so. So let's jump right into this. Into it. This particular slide answers that question. Why is the fiduciary in charge? The fiduciary is in charge because ERISA is a somewhat unusual or unique, I should say. It's a somewhat unique law in that it requires that there be a fiduciary of every employee benefit plan. The statute, which I quote on this particular slide, specifically states that every benefit plan must provide for a named fiduciary. So your document, in order to comply with federal law, needs to name a fiduciary. In addition, that document needs to provide that fiduciary with the authority and control to manage the operation of the plan. So that's why fiduciaries are in charge of benefit plans. It's a federal law. It's a federal requirement. Why is that? Why would Congress do something like that? It's a little unusual. When you come into work, you don't think of yourself as, you think of yourself as an employee, not a fiduciary usually. But this law, if you're dealing with a benefit plan, will create a regime where there is a fiduciary that needs to be overseeing that particular plan. And why did Congress do this? Because ERISA was a reaction to some poor employer conduct. Employers had offered employees benefits, basically made a promise, and there are some examples where they failed spectacularly. And Congress created ERISA to remedy that situation. And they thought one of the ways to help prevent that from occurring again is to focus both responsibility, authority, and, as you'll see, liability with a fiduciary. If you do that, people usually take notice, okay? So it's really important, this concept of who is the fiduciary. When you're setting up your benefit plans, it's an initial decision an employer must make, and it's one of the most important decisions they must make. But sadly, we often find that it's one of the least considered decisions that an employer will make. And Sam's going to make that point, probably in the next slide somewhat, but it doesn't get the attention it always needs, and that's really the purpose of this particular seminar, to give it the attention it deserves. I'll just leave you on this slide with this idea. Every ERISA plan has a fiduciary. There has to be one under federal. There is one, whether you know who it is or not. And the best example of that is if the Department of Labor audits your benefit plan, they will ask who the fiduciary is. If you don't know who it is, believe me, they will find a fiduciary. And that's really not how you want to operate your plan. You want to know in advance. So with that, Sam, I think you can go to the next slide.
Thanks, Ken. So as Ken said, the reason we wanted to give this talk on fiduciary governance is that the fiduciary governance structure, establishing a fiduciary governance structure for an ERISA plan, can be a really important step towards maintaining a compliant set of ERISA plans. And it's got primary benefits around making sure you're complying with all of the fiduciary requirements, but it can also have really nice secondary benefits where if you've assigned all of your fiduciary roles and made sure that those fiduciaries know what they're responsible for and what they need to be doing and what the consequences are if they don't do it, it can help make sure that all of those required activities get done, that all of your participant notices are getting sent out on time, that reporting with the government is getting done, and that there are good record keeping and documentation practices in place that can just have great benefits for overall ERISA compliance. But it's often a step that gets skipped. So what we're looking at on this slide is an excerpt from a retirement plan document. This is a portion of the adoption agreement for a 401k plan from a very popular vendor. It's likely that there's a lot of people watching this presentation that have this provision, this exact provision in their 401k plan document. And this item in the adoption agreement might be the only time that a lot of employers even think about their fiduciary governance structure, but it is very easy to just skip over this provision. And part of why that's the case is because it's set up exactly the way Ken was just talking about. If you look at the first line of section 1 of this provision, except to the extent elected otherwise, the employer shall be the administrator. So that's exactly what Ken was just saying. If you don't take any action, if you don't fill this out and assign these fiduciary roles, it just defaults to the employer as the plan administrator. And what we're hoping that we'll accomplish with this presentation is that you will understand what each of the sections of this provision does, why this is so important, and be able to make a start on understanding how to fill this out. Because having those fiduciary roles default to the employer can be a real problem. I mean, from our perspective, the initial issue there is that it's ambiguous, right? If the company is the plan administrator, what does that mean? The company can't do things. It can only act through people. And so if something goes wrong, if you get sued, or if the Department of Labor determines that there's some problem with plan compliance, they're going to find a person that they can hold responsible. And in most cases, the initial assumption is going to be that if the employer is the plan administrator, that means the board of directors is the plan administrator. That means the individual members of the board of directors are fiduciaries with respect to the plan. Or it might be your managing member or your managing partner if you have a different corporate structure. But that means that those individual members of your board of directors or your managing partner can be individually, personally liable for any breach of fiduciary duty that's happened. And in our experience, members of boards of directors don't like that. They don't want to be personally liable for those potential breaches of fiduciary duty. And they also might not have any meaningful direct interaction with those day-to-day plan operations that have caused the problem. And so a way to avoid that situation is just to create clarity, to assign those roles, to define the plan administrator and the investment fiduciary, and make sure that you know who's responsible for those things, and that the people who are responsible for them know that they're responsible for those things.
Yeah, I would say by naming the employer, it's often sort of a false sense of security. You have done exactly what ERISA says. You've named somebody, the administrator, the named fiduciary. But as Sam says, there's a lack of clarity there that can lead to a lot of problems, and we have some solutions to those problems.
So before we get too far into talking about how to set up a fiduciary governance structure, we want to step back and just make sure we're all on the same page about what a fiduciary is and how you know if somebody is a fiduciary. So the core defining characteristic of a fiduciary, in the ERISA context at least, is that they have this heightened responsibility. A fiduciary is responsible for acting solely in the best interest of participants. So your plan sponsor, the company, is going to make all kinds of decisions about an ERISA plan that are called settlor functions. So these are non-fiduciary decisions. And those are about the design of the plan. So who's going to be eligible, what benefit options are going to be provided, how much the employer contributions are going to be. And all of those decisions can and should be made taking into account the interests of the employer. What can you afford? What do you need to do to be competitive in your industry, to attract and retain talent? What do you want to do to reward your employees for their hard work? And all of those decisions are made taking into account the interests of the employer. But the fiduciaries of the plan are the people responsible for operations, and they're required to look out for the interests of the participant. They're required to make all decisions and take all of their actions when they're acting as a fiduciary solely in the best interest of participants. So when we're identifying who fiduciaries are, we look at the ERISA definition of fiduciary. And there are sort of two paths to having fiduciary responsibilities. One is the slide we were just looking at. One is naming that fiduciary in the plan document. So if they're identified as the plan administrator, they're going to have some fiduciary responsibility. But the ERISA definition of fiduciary is a functional definition. It's based on what people are actually doing. So if a person is acting as a fiduciary, even if they're not named in the plan document, and even if they don't know that they're a fiduciary, ERISA might still define that person as a fiduciary, and they'll still have that heightened responsibility. And the ERISA definition gives us, generally speaking, three paths into being a fiduciary. The first is having or exercising discretionary authority or responsibility in the administration of the plan. So if a person is making discretionary decisions about plan operations, that person is likely to be a fiduciary. The second is exercising discretionary authority or control over plan assets. And so this can take a couple forms. One of them would be investing plan assets. So actually making decisions about where the money in the plan will be invested. But the other one, that or in authority or control is important. If you are just holding plan assets, that's a fiduciary role. So even if the trustee for your plan is directed, or I guess in some contexts, they might not even be a trustee, but if you are holding plan assets, that's a fiduciary role, and you have fiduciary responsibility with respect to those plan assets. And then the third is rendering investment advice for compensation. And so this doesn't need to rise to the level of our second bullet. You don't need to actually be responsible for investing the assets. But if you are giving investment advice to the plan, you have a fiduciary responsibility related to that advice. And in all of these cases, understanding that definition and understanding who the fiduciaries are is important, not only because those fiduciaries should understand their heightened responsibility, but also because a fiduciary can be personally, individually liable for breaches of fiduciary duty. So if the plan loses money, if the plan is harmed as a result of a breach of fiduciary duty, the individual person, the individual fiduciary, can be required to make the plan whole. And so being in a fiduciary role comes with significant responsibilities and a significant degree of liability. So all of that is to say, it's very important to have the fiduciary governance structure in place that assigns those roles, makes it clear who's in them, and makes sure that everybody understands what their responsibilities are. So before we start setting up our structure and talking about how to design the fiduciary governance structure, just want to talk about who we're going to put into that structure. What are the fiduciaries that we're going to be placing within our fiduciary governance structure? And we're going to talk about two primary fiduciary roles in this presentation, and that's the plan administrator and the investment fiduciary. So these are our two key fiduciary roles that we want to make sure are assigned within our fiduciary governance structure. The first bullet on this list is the plan sponsor, and it's on there because it's a role that's important to bear in mind when we're talking about our fiduciary governance structure, but it is not in and of itself a fiduciary role. So as we talked about earlier, the plan sponsor is responsible for lots of non-fiduciary decisions about the design of the plan. And if there's no fiduciary governance structure in place, if nothing else is done, that plan sponsor might also be a plan fiduciary. But one of the things that a plan sponsor can do is take actions to delegate fiduciary responsibility, to create a fiduciary governance structure and assign these fiduciary roles. And one of the most important roles to assign is the plan administrator. So the plan administrator is who's responsible for day-to-day operations of the plan, for making sure required participant notices get sent out on time, that the 5500 gets filed, that employee withholdings make it into the plan in a timely manner, benefit payments actually get paid out, and for selecting and monitoring service providers who are going to assist in operation of the plan, making sure that those service providers are doing a good job and that the fees they're charging are reasonable. If you don't take any other action to assign fiduciary responsibilities, your plan administrator is also going to have some of the other roles that are on this page, right? They're going to be the investment fiduciary and the claims fiduciary, which we'll talk about more in a minute. But we think that it can be really valuable to separate those out. So thinking about the investment fiduciary as a specific role, the way it is in that plan provision that we looked at earlier, the investment fiduciary is the fiduciary responsible, unsurprisingly, for making investment decisions. And in a classic defined benefit pension plan and in some defined contribution plans, that means actually investing the plan's money. So choosing which funds, which stocks, which investments the plan assets are going to be put into. In a defined contribution plan, an individual account plan, like a 401k plan, the investment fiduciary is responsible for selecting the investment menu, selecting the funds that are going to be presented to participants when they choose where to invest the money in their account. And that means selecting the funds, monitoring them to make sure that they're performing appropriately, and also making sure that the fees charged by those funds are reasonable, and that the overall investment lineup provides participants with an opportunity to build an appropriately diverse portfolio. And so the investment fiduciary needs to select those funds, monitor them, decide whether they need to be removed or replaced or new funds need to be added. The other fiduciaries that we'll mention briefly, but focus less time on, are the claims fiduciary and the trustee. So the trustee is always going to be a fiduciary because they hold plan assets. And it's fairly typical to have the trustee be what's called a directed trustee. So they're not actually responsible for any discretionary decisions about plan assets. They don't manage the money. They just do what the plan fiduciaries tell them to do. But they are still a fiduciary in their role holding plan assets. Some trustees have more discretion around investing plan funds. They might also be the investment fiduciary. But in any case, the trustee is going to be a fiduciary. The other that we'll talk about a bit more in a minute is the claims fiduciary. So the claims fiduciary is responsible for deciding whether participants are eligible for benefits. So when an employee submits a claim asking for money under the plan, the claims fiduciary is responsible for deciding whether the participant is eligible to receive that benefit. In a retirement plan, that's typically going to be the plan administrator, and you don't delegate a separate claims fiduciary. But in a welfare benefit plan, in a health plan, a long-term disability plan, you are usually going to have a separate claims fiduciary. And it's usually going to be the insurance company or the third-party administrator for that benefit. So that when an employee submits a claim to the health FSA asking for reimbursement for some expense, it's going to be whoever's responsible for administering the health FSA, which might be a third party, that makes a decision about whether to grant that reimbursement. And that person is going to be the claims fiduciary. So in the context of a welfare plan, that is another role that our plan administrator is going to appoint, and that we need to make sure is clear in our fiduciary governance structure. So if we go back to this plan provision that we looked at earlier, I think we can see where a lot of what we've talked about comes to bear in the language of this provision, right? So we talked earlier about how if you don't take any action, this provision defaults the employer to being the administrator, and why that can be a problem. So, okay, we don't want the employer to be the administrator. So now we're going to go down to Section A and we're going to assign a plan administrator. And this gives us an opportunity to do that. So, okay, now we don't take any other action. That means that the plan administrator is also going to be the investment fiduciary. You can see in line B that it's the name of the investment fiduciary, if not the administrator. But okay, we want to separate out our administrator and our investment fiduciary because we think those roles are different and we want different people doing it. So we're now going to go to line B and we're going to assign an investment fiduciary. And if we have any other roles we want to assign, this gives us the option to go to an addendum and craft a more complicated system. But just using the language that's here, just using items A and B, we can assign our plan administrator and we can assign our investment fiduciary. And now our plan document names those entities. But even if our plan document names these fiduciaries, there are still actions we need to take to make sure that that governance structure is actually implemented in practice, right? The plan document can say somebody's the plan administrator, but that doesn't actually make them a plan administrator. So what we need to do is put in place a fiduciary governance structure. And the basic goal here is to make sure that we've thought about what all the roles are, right? The roles that we discussed a couple slides ago, and who we want to fulfill those roles, and then delegate responsibility to them. Take actions to make sure that they have that authority and have that responsibility, and then make sure that those individuals know that that's the role they're in. And generally, that's going to be done through an action of the board of directors, appointing committees or assigning individuals to the various fiduciary roles. If it's going to be individuals, which is not entirely uncommon, it's generally going to be by job title, so that if somebody leaves, you don't suddenly have some person who doesn't work at your company named as your plan administrator. So it's somewhat common to have your head of HR be named as a fiduciary for the plan. We think there are benefits, especially with a larger company, to having the fiduciaries be committees. So it's fairly typical for the board to create committees and then delegate those fiduciary roles to committees. So this is a classic fiduciary governance structure. You've got your company, your plan sponsor at the top acting through the board of directors. And like we said, we don't want our board of directors to just default into being the plan administrator. I suppose you could decide you want your board of directors to be the plan administrator, and that's fine, but it should be a conscious decision. You shouldn't just default into it. So in order to avoid defaulting into the board of directors being the plan administrator and having those other fiduciary functions, the board of directors is going to take an action to create an administrative committee. And they're going to serve as the plan administrator. And the board of directors is going to delegate that plan administrative authority and that responsibility to that administrative committee. So now the board of directors doesn't have those fiduciary responsibilities as plan administrator. Instead, the board of directors' only fiduciary responsibility is that they prudently selected this committee, which we hope is the case, and that they're making sure that the committee is doing their job. And so we want our committee to report back to the board of directors, let them know that all the administrative functions are happening. So now we've got our administrative committee. They're the plan administrator. We have a board of director action creating them. The administrative committee should put a charter in place saying what they're going to do, hold regular meetings, keep minutes, and they're plugging away. They're the plan administrator. If this is a welfare plan, then we have this next step of the plan administrator appointing a claims fiduciary. It's similar to what the board of directors did, right? We have a delegation of authority from the plan administrator to the claims fiduciary. In a retirement plan, you're less likely to do that. And if we move over to the other side of the chart, we have our investment fiduciary. So those might be one committee, one administrative and investment committee, but they are very different roles and they involve very different types of expertise. And an important part of fulfilling fiduciary duties is acting the way a prudent, and Ken will talk about this in more detail, but acting the way a prudent expert would act. So you need to either have or go out and get expertise in the thing that you're responsible for taking care of. And the investment committee in particular, that's a very high level of specialized knowledge. And so separating out the administrative committee and the investment committee so that they have defined roles can have benefits. For the reason that I was just saying, that required expertise, the investment committee is generally, I think close to being a requirement, going to hire an investment advisor to provide advice on those investments. And that might be a non-discretionary investment consultant. That's sometimes called a 321 fiduciary. The numbers are a reference to the ERISA provision that sets the definition. And that's somebody who's just going to provide information to the committee. They're going to make recommendations about investments, but that 321 fiduciary is not going to be responsible for actually investing the assets. So they have a fiduciary responsibility when they're giving advice, but they're not responsible for whether or not the committee actually follows that advice. It's the committee who's ultimately responsible for the investment decisions. Another path that some plans take, and this could be instead of the investment committee, it might be along with it, is a full-blown investment manager, a 338 fiduciary who has discretionary authority over the management of plan assets. So that's going to be an investment advisor who actually makes the decisions about investing plan assets. And they're going to have all of that fiduciary responsibility around those investment decisions. And so that's our basic overview of the structure we want to have in place and what each of those roles requires. And Ken is going to get into, okay, so we've established this structure. What do we need to do to make sure it all works and that our fiduciaries are fulfilling their responsibilities?
Sam, before you go there, though, I want to just pause on this slide for a minute, because this is a great slide. And as Sam said, this is a classic fiduciary structure. And I want to make, I think, 2 points here. And the first, I think Sam covered, but it's worth emphasizing. The board of directors in this slide has a fiduciary obligation to delegate. So they need to delegate to the right people, right? So that's one thing. They can never get out of that obligation, but once they delegate, then they're no longer responsible, for example, for investments. But they need to get the right people. They have a fiduciary responsibility to get the right people in place. And they have a duty to monitor. That's their biggest duty, to monitor these in committees. So the committee should report back up to them and let them know that they are doing their job. So they need to monitor and they need to get the right people in place. We have seen examples where boards have named individuals to committees, and those people no longer work at the company, and yet they're still named. So almost by definition, they've breached their fiduciary duty in delegating and monitoring if they don't really even understand who they have in place. So it's really important for them to understand, once they delegate, their job is never completely done. They still have a role to play. And that's why Sam said in one of the earlier slides, we typically have the board name individuals by title, because the titles change less than the people. But even that is not always true. A lot of times titles change. So we'll often say title or similar position, because you're always chasing your tail a lot of times. So that's really important. The other point I want to, is really a question for Sam, and this is the classic fiduciary structure. And on the prior page, we had a classic adoption agreement on this page. And the question is, Sam, how would you fill this page out based on that slide? It would be different than how it is right here. And do those large record keepers who offer these documents fill these out properly? So you could do everything right and have that great structure that Sam just outlined, the classic structure. And does it get onto this page?
Yeah, right. And that last point is a good one. The vendor that created this document and sends it to you to fill out is very unlikely to fill out this section. We've seen it happen where even with an employer who's been using that vendor for a while and has previously had plan administrators named in their document, sometimes it doesn't make it in here when the document gets redone, when it gets restated. So it's important to double check and make sure that this section is filled out correctly, because we do want it to reflect our nice structure that we put into place. And so if we were taking this classic governance structure that's on the slide and putting it into that provision in the plan document, item A, our administrator is going to be named as the company administrative committee, or whatever title it is you've given to that administrative committee. And then you're going to check the box on B and fill that in with company investment committee, or it's probably company retirement plan investment committee, whatever it is you've chosen to name the committee. And I think the risk there, the reason we want to make sure the plan document reflects our structure that we've gotten, that we've spent all this time putting in place, is that, even if the plan document doesn't accurately describe who the plan administrator is, it might still be the case that if you got into a lawsuit, ultimately that committee is still going to be the plan administrator, and the board of directors isn't going to have those responsibilities. But you've created an ambiguity. You spent all this time creating this beautiful fiduciary governance structure in order to remove ambiguity about who's in what role, and then gone and created ambiguity again by not having the plan document match up with it. And so what you've done is just created an argument that you need to have in the event that you have a lawsuit, when you put this whole nice structure in place and could have just completely avoided that. You could have named it in the plan document, and then there'd be no question about who's the plan administrator, who's responsible for those day-to-day administrative fiduciary functions.
Great. We actually have a question that's sort of apropos to what we were just discussing. And the question is, should the investment committee members be named by name or position? If by name, what's the best practice if when they leave the company? So we've talked a little bit about this. We have named individuals, but they leave quite often. And so we find by position is the better practice. But even then, it's not set it and forget it. You do have to keep revisiting because positions change. And then the second part of the question, if when they leave the company, it's best if the delegation is such that, and this will often be reflected in the charter for the committee, it's best if when they leave, they automatically come off the committee. I have seen individuals, I've seen structures where they actually had to agree to leave, and that is really cumbersome when they're leaving. So I wouldn't do that. So positions over people, and then they come off when they leave. The question is, if we have an investment advisor, do we have to list them on the restated document in addition to the retirement committee? I think the answer is no, you don't have to do that. They are a co-fiduciary with the investment committee or the retirement committee. The retirement committee typically hires that investment advisor. So really in your example, what you really need to get on that document is the retirement committee. So I think those are the two questions. Sam, if you wanted to go to slide 9. So what we've been talking about is trying to identify the fiduciary and the fiduciary structure. And once you've done that, what is next? And the short answer there is training. But fiduciary training is probably a program in and of itself. But what I want to do is hit the highlights of what these fiduciaries, once you've got the structure in place and once you've got them in place and they know who they are, these are the basics that they want to know. But fiduciary training could take up a whole program. So we won't spend a lot of time on training, or as much time as we typically would. So what do the fiduciaries need to know now that we're all set, we have our structure in place? They need to know basically 4 things. 1, they need to know what they're responsible for. Are they responsible for investments? Are they responsible for administration? Are they responsible for claims? Are they responsible for everything? They need to just understand what they're responsible for. Second, they need to know what their core fiduciary duties are. ERISA imposes duties on these fiduciaries, and there are 4 fiduciary duties, which I'll cover shortly, but they need to know their fiduciary duties. As part of those duties, you'll see one of the things, a concept that I think is really important, and it's a concept that really got messed up that we'll talk about in the litigation section, is this doctrine of 2 hats. And some people love it and some people hate it. I tend to like the doctrine of 2 hats. And it's this concept that courts have discussed, where when you are acting as a fiduciary, you need to be wearing your fiduciary hat. And that means you need to take off your company hat or your employer hat. You really need to have your fiduciary hat on. Sam mentioned we're acting solely in the interest of participants. That's what this means. You need to put your fiduciary hat on. And this is just a fundamental aspect where fiduciaries can get all confused as to what is their role. And if they understand they need to be acting with their fiduciary hat on, it really simplifies the whole process. The 4th thing that fiduciaries need to know, and Sam actually also mentioned this too, but we're trying to gather all these important knowledge things, training things in one place, is that they are personally liable if they do not fulfill their fiduciary duties. This is another unique aspect of ERISA. You don't see a lot of laws that impose personal liability on an employee. I don't think when they go to work, they think of themselves as personally liable for anything. But if they happen to be a fiduciary, they can be personally liable. And this is a surprise to many fiduciaries who are first-time fiduciaries. Jumping to the next slide, Sam. So these are the core ERISA fiduciary duties that a fiduciary should know about. The first, and perhaps the most important, is the duty of loyalty. When you are acting as a fiduciary, you must act solely, absolutely solely, in the best interest of participants and beneficiaries. So it goes back to that two-hat concept. You have to have your fiduciary hat on when you are acting as a fiduciary. You cannot be thinking what's in the best interest of the company. You cannot be thinking what's in your own best interest. You have to act in the interest of participants. And so it's a very high standard. And so when we get to litigation, you can see why there's been a lot of litigation, because fiduciaries are exposed by this high duty. They have a high standard to live up to. And if they don't live up to it, there are a lot of lawsuits around that. And that all really stems from the duty of loyalty. In addition, the duty of care, a very important duty. This duty is also called the duty of prudence. And it requires, I know there's funny language on this, the use of care, skill, prudence, and diligence. But that really comes from the statute. That's what federal law says you must do. You must use care, skill, prudence, and diligence. And then it goes on to say of a prudent, it actually says a prudent man, because the law, ERISA, was passed in 1974. It's really a prudent person, but courts have interpreted it, and we've kind of fashioned it into this bullet. Courts have fashioned this standard as not a prudent person standard, but it's a prudent expert standard. So with respect to this duty, there are really two important things to take away. Courts apply this prudent expert standard. So if you're an investment fiduciary, if you're on that investment committee, you're the X Corporation Retirement Investment Committee, and you're selecting investments for a DB plan, or you're selecting funds for a 401k plan, and you are not an expert with respect to investments, you really need to get someone to assist you who is an expert in that area. You really need expertise when you are trying to fulfill this duty of prudence. The other important thing, and which is a very helpful thing to fiduciaries, is it's all at the time, we say here, the prevailing circumstances. It's at the time you're making decisions that you will be judged. So if you use the care, skill, and prudence in making a decision at that time, and then that decision turns out to be not the one you really would have liked. Let's say you select an investment, just sticking with that theme, and it turns out not to perform in the way that you would like it to perform. Courts will not second guess you if you were prudent when you made the selection. And of course, if you were prudent when you made the selection, you're more likely to make a good selection. So there's no second guessing of the decision down the road if you make a prudent decision at that time. That's a really important point with respect to the duty of care. So what that means is you want to know that you're a fiduciary, and you want to be sure that you're making a prudent decision. The third duty is the duty to diversify investments to minimize risk of large loss. This is best exemplified in a defined benefit plan. You really shouldn't put all the assets in one basket where you could lose them all. That would be a breach of your fiduciary duty. When it comes to 401k plans, there's a little bit of a different rule, because if you think about 401k plans, the investment fiduciary is typically not making investment decisions on behalf of the participants. They do sometimes, but that's a minority of plans. They are often just providing an array of funds for the participant to choose from. And if they do that prudently, there's some rules that you have to follow. But if they provide an array of funds with different risk and return characteristics, then if the participant puts all their eggs in one fund basket and loses money, the fiduciary will not be liable for those losses. So that's the duty to diversify. And then the fourth one, which is a really important decision, a really important duty, is that fiduciaries must follow their written plan document. ERISA requires there be a written plan document because Congress wanted employers to put their promises in writing. And when fiduciaries are making sure these promises are being fulfilled, you must go back to the document. And I assume the document complies with ERISA, of course. So you must follow the plan document. And many, many, many questions that arise in the context of deciding questions with respect to benefits. The first question you're always going to have to ask and answer is, what does the plan document say? That's really the starting point for those kinds of things. Jumping to the next slide, Sam. So how do you fulfill these duties? I'm going to jump through this slide very quickly because I've touched on it. But a fiduciary goes a long way toward satisfying their fiduciary duties if they engage in a prudent process and they document that process. And by this, we mean, by process, the best example is that you go back to our slide about the design and you have a committee. That committee meets regularly and reviews the plan, right? You have regular meetings. That's an excellent example of process. And during that meeting, you consider important matters. That's the process part of it. The second part of it, where you'll often see some folks falling down, is you then need to document it, okay? And the way we document the process usually is through meeting minutes. Meeting minutes are, in our view, they are not a transcript of what happened at that meeting, okay? They are true minutes. They're reflecting the decisions made and why those decisions were made. You don't want a transcript of what happened. That will cause more problems than not, probably. And just on that point, just the importance of that particular point, we're involved in litigation right now. Defense counsel, another firm, had a meeting this week. What was the topic of that meeting? It was, where is the documentation of meetings? That's all we want. We just want the documentation. They don't want to know that there were meetings. They want the documentation of the meetings. And that's a threshold question that came up. This is $1 billion plan. It's an important thing. You do not want to be thinking about this after a lawsuit has been filed. So jumping to the next slide and jumping right into litigation. 3 points here I want to make. The first is there has been an explosion in litigation against ERISA fiduciaries. They're really kind of easy targets in a sense. They're subject to a high standard, and you can see how complicated it is to get this structure in place. And even if you have this structure in place, Sam explained that sometimes it doesn't even get transferred to the plan document. It's an area where plaintiffs' lawyers can have a lot of fun. And they have in the last 15 years. One firm one firm alone has brought claims. They say that they've recovered $1.5 billion. That's a lot for about a 20-person law firm. Now there are a lot of copycat suits. Just in 2000, there were more than 200 class action lawsuits, and these often are class action lawsuits because all the participants in the plan get together and they file a complaint. And these suits are coming down sort of the food chain. They started with John Deere, Walmart, huge companies. Now we've seen them against auto body shops in Connecticut. So they're coming down. So if you do the things that we have been talking about, if you create a structure, if you identify the fiduciaries and you train the fiduciaries, let me tell you, you're going a long way towards minimizing your risk of litigation. All right, common claims. I've set forth some common claims here. I'm only going to highlight 3 here. The classic claims are poor performing funds and high fees. Now, if you have a fiduciary in place, they know that they're the fiduciary, they've been trained, they're going to be looking at performance and they're going to be looking at fees. And that's really going to minimize their risk of loss. The other thing under common claims, this is just a prediction. You know, it's always bad to make predictions, but going forward, I think you're going to see more claims in the area of cybersecurity. I say that because the Department of Labor within the last year came out and said, fiduciaries, you have an obligation to monitor cybersecurity. The last point on
Ken, I would just note that that monitoring cybersecurity, it's both your own cybersecurity for the plan and also to make sure that the vendors you're using, that the people you've hired have cybersecurity programs in place.
Absolutely. And, you know, to follow on to that, a lot of the vendors have sort of cybersecurity guarantees, but you need to do certain things to qualify. So you need to know about those. So cybersecurity is only going to become more and more important. The last thing I wanted to mention on litigation is this two hats concept. Just this case, Tussey versus ABB. This is the granddaddy of all fiduciary litigation in the fee and performance category over the last 15 years. It's just it just shows you this hat concept that I was talking about, and I'll give you the facts really quickly because I want to get to the last page. Fidelity provided record-keeping services to ABB's retirement plan, a huge retirement plan. They also provided services to the corporation ABB in the form of payroll services and other things. ABB's fiduciaries had a consultant, Mercer, well-known consultant, and Mercer told the fiduciaries that you are overpaying for record-keeping fees and you appear to be subsidizing corporate services. Now think about that for a second. When I say you were overpaying for record-keeping fees, it was actually the participants in the plan were overpaying record-keeping fees for their retirement plan, and the corporation was getting a benefit in the form of free or close to free payroll services. That was the allegation. If these fiduciaries understood this two-hat concept, that they needed to have their fiduciary hat on, they needed to act solely in the interest of participants, they would have immediately understood that having participants overpay for record-keeping services in the retirement plan, so that, and maybe it's not so that, but as part of the corporation getting a break on payroll services, is going to, at a minimum, look bad and maybe a breach of fiduciary duty. And so that's an example where I think whoever was making these decisions had the wrong hat on when they were making they had their corporate or employer hat on when they were looking at these participant fees. So with that, let's go to the last slide. So what's next? What are the next steps? What we would recommend are the first two steps on this page are sort of inventory items. You know, take stock, look at your plan documents and see who do they name as the fiduciary. And then look around and see, because Sam said a fiduciary is a functional definition. To the extent someone is exercising discretion and control, they're a fiduciary. Okay, so just inventory. Who do you think are in those categories? Then third, look at your look at what your desired design is, the plan document and operation, and make sure they all align. Make sure that the plan document is in accordance with your governance structure, which is in accordance with the people who you want in control of your plan. That's critical to so that you're all on the same page, so to speak, literally and figuratively, I guess, in this case. Then provide fiduciary training, right? Let these fiduciaries know, because it's a big responsibility to be a fiduciary, but the worst thing is to have people who don't even know they're a fiduciary. That's going to lead to disaster. So provide training, get the structure in place, provide the training. These fiduciaries are going to want to have in place certain governing documents, in particular, a charter and an investment policy statement. And then once you've done that, take a look and see if you have fiduciary insurance and indemnification provisions. And on insurance, just a super important thing that gets confused all the time, ERISA requires plans to have fiduciary bonds, and it's reported on the Form 5500. That's not what I'm talking about. A bond protects the plan. What I'm talking about is something that's not required by ERISA, but is good to have, and that's fiduciary insurance that covers the fiduciaries. It covers the company or the fiduciary in the event of a fiduciary breach. And then indemnification provisions are provisions where the corporation says they will indemnify the fiduciary, so long as the fiduciary wasn't negligent or fraudulent or that kind of thing. So you really want to have that in place for these fiduciaries because, like I said, it's an important role.
Yeah, we've talked a bunch of times during this presentation about how fiduciaries can be individually liable, which could potentially be a barrier to getting anybody to agree to serve as a fiduciary. But the fiduciary liability insurance and those indemnification provisions are how you make sure somebody's willing to do it, right? That's how we make sure that somebody gets reimbursed if they are held individually liable. And I think those indemnification provisions can be a sneaky thing that gets overlooked, because the insured under the liability insurance policy is very likely to be the company. And the indemnification provisions are how we put down in writing that if there's a breach of fiduciary duty and the insurance policy pays out to the company, that it's actually going to get paid down to the fiduciary that was held individually liable if they are. Did you have anything else on the next steps, Ken?
I think that was it. No. If anybody had any questions, we're happy to remain on the line. You can put them in the chat, or you could just ask them. Sam, I'd ask you one question back on your kind of classic fiduciary diagram. You showed 2 committees. Does it have to be 2 committees?
Yeah, so it's not uncommon to see the plan administrator and the investment committee, that those responsibilities are combined into one committee. The reason I think the classic structure with 2 separate committees makes sense is that, especially in the case of that investment fiduciary role, so much specialized knowledge is required to invest retirement plan assets. I mean, that is a big responsibility that there's a reason that investment advisors exist and that they get paid a bunch of money to do what they do. It's hard. And so separating that out, making sure that the right people are on the investment committee can be a good reason to have 2 separate committees.
All right, great. I forgot to mention there is a raise your hand option under there too, if you have any questions. And I would just add to that employers that offer employer stock in their plans will often have 2 committees, one for the investment and one for administration, and they'll have different sort of people from finance on the investment committee. Typically, someone a little bit lower down the totem pole has been a classic structure in the investment committee, because you don't want people higher up who have knowledge of the company making decisions around employer stock. So I don't see any questions. So I guess we'll leave it there for today, and hope you all have a good day. And again, it's a happy St. Patrick's Day to everybody. Thank you.